A very warm welcome to today's webinar. I'm Jonathan Schützer. I'm an associate professor at Uppsala University and also the chair for the Emerging Scholars Group. And today we're going to talk about creditor-led restructurings and workouts, a global exchange hosted by Insolvency Law Academy's Emerging Scholars Group in partnership with iWork, that is the International Women's Insolvency and Restructuring Confederation. And this event is part of our ongoing series of conversations bringing together leading voices in insolvency and restructuring. And in the past, the Emerging Scholars Group has hosted a fireside chat on environmental obligations in insolvency. And in January, we will feature several panels at the Insolvency Law Academy annual conference in Hyderabad. And today we will focus to how creditor-led restructuring are shaping businesses' recovery across borders. And my co-chair of ESG will moderate this session, Ishana Tripathi, who is a director for research and innovation at SMA and Co. Please, Ishana.
Thank you so much, Jonathan. Welcome, everybody, wherever you're signing in from. Good morning, good evening, good afternoon. And thank you for joining us. Thank you for supporting this first initiative and collaboration as a leading voice panel on creditor-led restructurings across various jurisdictions. And we hope to essentially keep you engaged in different perspectives and different jurisdiction issues when it comes to creditor-led restructurings, which in its own has a very interesting connotation in the jurisdictions that are on display. I will now just quickly introduce the speakers in the panel lists today to you. It is a fantastic lineup, a fantastic experience board that we have today, and I will let you Google them simultaneously because their accolades cannot fit into the 1.5 hour that we have, and I want this to be a more engaged conversation on bankruptcy. So therefore, I will keep their introductions brief as per the slides that you can see. So first up, we start with Singapore. We have Jo Tay, who's a partner at Allen and Gladhill. We move across the pond to Hong Kong with Veronica Chen, a partner at Tanner Day Witt. Then we come back a little more south, where Veena Sivaramakrishnan, who's a partner and co-head of the banking and finance practice at Shardula Marchand Mangaldas and Co. India. Then a little more ocean to cross, and we have Stine Sniklandalen, who's the partner and head of restructuring and insolvency at Quale, Norway. And finally, we do another round about and land in the United Kingdom with Charlotte Moeller, who's a partner at Squire Patton and Boggs. Now, the reason why we've gone with this jurisdictional as a global exchange is because we're predominantly looking at jurisdiction transplant culture, with Singapore leading the way for Asia, while borrowing from the US and the UK to some parts, predominantly the UK, and then ending with where most jurisdictions borrow their restructuring culture from, which is why we have UK at the end. And we have hybrid models, similarities in the middle with Hong Kong, India, and Norway. So without too much of hearing my voice, I'm just going to allow the leading voices to take over and start the conversation on creditor-led restructurings and workouts with our first speaker for today, Jo Tay. Once again, thank you, Jo. I'm extremely glad to call you a friend, and also very grateful that you were able to come be the starting of this particular session and give the background and structure that Singapore provides and lends to creditor-led restructurings and workouts. So welcome to the floor, and the floor is yours.
Okay, thanks very much, Ishana. And I'm happy to be here today just to give everyone a very quick overview of what it looks like, what the restructuring landscape looks like in Singapore, and how exactly do creditors feature in the entire restructuring process in Singapore. Now let's start with the basics. To me, when we talk about restructuring, it's anything to deal with the insolvency of a company outside of the liquidation regime. So I will cover a little bit on informal workouts as well as the formal regime, schemes and judicial management, before moving on to talk about how the creditors feature in leading the restructurings in these proceedings. So as I said, the formal regimes, you have schemes of arrangement and judicial management. Now, a scheme of arrangement shouldn't be, I guess, a foreign term to anybody here. By and large, it was adapted from the English system a very, very long time ago. We know it's a debtor in possession proceeding, and we know that management is the one that proposes a scheme for creditors to vote on. You need to have it passed by a majority number holding 75% in value of debt in each class. Now, some of us may or may not know that this scheme of arrangement regime that we inherited from the English underwent major amendments, plastic surgery in 2017 or 2018 when Singapore decided to import features from Chapter 11 in the US and transplant them onto our system here in Singapore, which means now that our scheme of arrangement proceedings come with immediate moratoriums the moment the debtor files and says that I have an intention to propose a scheme. I want 30 days protection for me to put together a plan, and in 30 days time I'll be before the court to ask the court for more time to negotiate with the creditors. It comes with a pre-pack, cram downs, rescue financing, things that you would be familiar with if you look at the US system. We have it all here in Singapore, having looked internationally to see what's helpful and brought them and imported them into Singapore. We also have judicial management. Again, this is administration inherited from the English, just that we changed its name when it came into Singapore. We call it judicial management, JM for short. The proceeding itself is called JM. The judicial manager is also called JM. Generally, we don't get confused for some reason. Okay, because we know pretty much what we're talking about when we talk about the judicial management and the judicial manager. Now, this is a system in which the company or creditor puts a third-party insolvency professional in place, and the judicial manager, JM, goes in to run the company and proposes the restructuring. Now, there is no formal statutory provision by which a creditor can put forward a plan for creditors to vote on. But by and large, if creditors do want to have a lead in these proceedings, I'd say put together an ad hoc group of creditors so that you have larger bargaining power, or if the company or if the creditor itself has one of the largest votes, really have a look at strategically which class of creditors you would be placed in and how much say you would have in the proceeding. And from there, as a starting point, be very clear to the company that these are certain things we want, otherwise your scheme is not going to pass. For judicial managers, a lot of the creditors are actually directly in contact with the judicial manager, especially if they were the ones who put them in the first place. So that's another way in which creditors do have a voice or a way of influencing the way the restructuring goes. I'd say practically there are fights around a couple of issues in both scheme and judicial management proceedings. Information, valuation, which professional goes in. Information, of course, is because the company is always in a better position to propose a suitable plan because they have immediate up-to-date information about the company and where it's at financially. Now, there are disclosure requirements as part of the scheme and judicial management, but they're not immediately up-to-date and no one knows whether it's just given by the company. So you don't know whether it's accurate or not. And to ask a creditor to then formulate a plan based on whatever limited information they have, you can see how that's going to be very difficult for the creditor. So if a creditor wants to propose a plan, it will first have to wrestle information out of the company or make use of whatever the court orders disclosure for. Second, valuation. Again, art and science, especially when it comes to cash flow projections, there's plenty that professionals can fight about. Finally, what professional goes in? Honestly, everyone has a favorite, and everyone distrusts the professional that the company wants to put in. So you can imagine that recently there has been a lot of case law that has sprung up around the choice of professionals and how the court will decide which professional to appoint in each situation. Moving on to informal workouts very quickly. Honestly, anything goes depending on who has more bargaining power, who has security. Though I would add that with the introductions of moratoriums around 2017 or 2018 in Singapore, the companies do have more bargaining power because they can go ahead and apply for a moratorium if the negotiations with the creditors don't work out. So that's a chip that they have in hand. I can go more into cross-border situations later, but just a couple of things I would say. First, it's that foreign companies can actually use the Singapore restructuring regimes if they have a substantial connection to Singapore. I think the more difficult question is if a creditor wants the company to restructure in Singapore, but the company doesn't, is there any way of pulling them into the jurisdiction? So that's a question that I think is a more strategic one, and I think professionals have to be creative around it. Second is that if we can use the model law to assist foreign restructuring proceedings, and so whether and the extent to which creditors have a say in those restructuring proceedings would be very much led by what's happening in the primary jurisdiction. I am happy to elaborate more on that later, but I'm also at this point happy to cede the stage back to Ishana or to my next speaker.
Sorry, I had some trouble figuring out how to unmute. Thank you so much, Joe. I would now like to move across the pond to Hong Kong and invite Veronica Chan to give some perspectives from the Hong Kong perspective. Veronica is a partner at Tanner DeWitt and comes with a large amount of experience in the space of restructurings, liquidations, and would perhaps give us a better perspective from the PRC perspective as well. Veronica, over to you.
Thank you, Ishana. Hi, everyone. Not much of an introduction needed because Ishana has done a good job already. So just to set a scene, Hong Kong is a creditor-led jurisdiction. Similar to, oh, is it my mic on? So similar to what Joe said, in relation to scheme, we also need to have a majority of 75% of numbers of vote by creditors to pass a scheme. So I'm not going to go too much into that. One thing I want to point out is Hong Kong does not adopt the model law. So a lot of our system is based on common law principles. But what is special happening around here is that recently on the 14th of May 2021, Hong Kong and mainland China has agreed on a mutual cooperation mechanism to recognize and assist insolvency proceedings in both Hong Kong and China. And this provides a threefold function. Firstly, to provide legal basis for the recognition of Hong Kong office holders and proceedings in the PRC, which has stressed some long-standing difficulties of recognition of Hong Kong office holders in the mainland. It also demonstrates the PRC courts embracing for some sort of modernization in cross-border insolvencies. And it also helped the judges in the PRC to familiarize the necessity on this kind of approach and the concept of recognition and assistance. However, this cooperation mechanism only applies to 3 cities in the mainland. We call it the pilot areas. They are Shenzhen, Shanghai, and Xiamen. So I'm going to tell you a little bit how this mechanism works. So usually we will say an outbound or inbound recognition. I'm going to start with outbound recognition, meaning to recognize Hong Kong insolvency proceedings in the PRC. So prior to this cooperation mechanism, there's only one article under the PRC bankruptcy law which provides some sort of guidance on insolvency, cross-border insolvency. However, under the new cooperation mechanism, office holder in Hong Kong can apply to the court for a letter of request to be submitted to the mainland court in one of these 3 pilot cities to be recognized. And in the Hong Kong case called the Trinity International Brands, the new Hong Kong companies judge have set out the criteria and requirements for a letter of request to be granted by the Hong Kong court. Namely, the application must be made by a Hong Kong liquidator in the Hong Kong insolvency proceedings. And the recognition has to be sought from the court within the pilot area. So if there's any area outside the 3 cities, then the letter of request will not be granted. And the powers sought must be also within the Hong Kong liquidator's powers that can be exercised under Hong Kong law. And obviously, COMI, as adopted in the Hong Kong under the recent cross-border insolvency proceedings, is also applicable when the court determines whether or not to grant the letter of request. And then all the assets of this company must be in the PRC, especially in these pilot areas. And then finally, the recognition and assistance sought must be necessary for these Hong Kong liquidators to carry out their duties in the mainland. So we call this the necessity requirement. However, the law is still not very clear because it's not an automatic recognition. So even if a Hong Kong court has issued a letter of request, it is still a discretionary power of the PRC courts as to agree or refuse to grant such recognition. So we will just have to wait and see what's going to happen when there's more case law to frame the whole guidance. So we've talked about outbound recognition. And what about inbound recognition, meaning application in the mainland China for recognition of their insolvency proceedings in Hong Kong? Under the cooperation mechanism, the process of recognizing the PRC proceedings in Hong Kong remains largely the same as we applied for the letter of request from Hong Kong court. Again, these requests must be made by the pilot areas. There aren't that many cases so far, but there are actually more cases coming through outside of the pilot areas. So what do we do in Hong Kong? We are actually having increasing number of cases, also showing that Hong Kong court is quite willing to recognize insolvency proceedings even outside pilot areas. So as mentioned, common law is the basic principles. So when a cooperation mechanism doesn't apply, we'll always apply the common law principles. So the first case in Hong Kong that recognized the PRC insolvency proceedings is called the Hainan Airlines Group in 2021. This is a request made by the Hainan province in the mainland and successfully recognized in Hong Kong. And then subsequently in 2023, a case of Guangdong overseas, similarly, Guangzhou is not one of the pilot areas. So the cooperation mechanism doesn't apply, but the court nevertheless provided recognition and assistance by way of common law principles. So that and this is also because the mainland insolvency proceedings were collective and conducted the company's COMI, center of the main interest, and therefore the Hong Kong is more than willing to grant the recognition. So as I said, there aren't that many cases that have applied this cooperation mechanism. So far, we are like four years down the road. There are only about 8 applications in Hong Kong that have applied for recognition under the new cooperation mechanism. And not all of them were successful. And as I said, this only provide a guideline to us. It's not like a set law that provides certainty to us, unlike model law. So largely it's also based on the PRC cost discretionary power. And I don't practice PRC law, but what I understand from like my PRC colleagues is that a lot of the judges in the PRC, they might be familiar with cross-border insolvency, but not insolvency law itself, so or vice versa. So there is still a lot of room for improvement. And the other thing is there are only 3 pilot cities that can apply the cooperation mechanism. Therefore, with the increasing numbers, as I said, there are actually more cases outside these pilot cities. We do see room that we may increase the number of pilot cities, so more cities in China can make use of the mechanism and provide a more cost-effective and efficient way to implement a cross-border insolvency proceedings, including scheme of arrangements.
Thanks so much for that perspective, Veronica. I think what's very significant from a Singapore and also a Hong Kong perspective is and that we'll get to later, is the whole mutual recognition and assistance. And that is a question that I will raise to you preemptively. Moving on to the next jurisdiction on the lineup, where there is a lot happening in terms of legislation and change, we have India, and I would like to invite Veena to speak about where the Indian market is when it comes to restructurings and workouts that are creditor-led, and also the new regime in the pipeline.
Hi everyone. Good afternoon or good morning where you are based, but it's really a pleasure to be here. Let me first thank the organizers for having us. It's actually very enriching, not just for the participants, but for us as practitioners to also hear about other jurisdictions and to see the developments that happens across jurisdictions and how this law is evolving. Coming to India, let me say that most of us have sort of evolved from being finance professionals or M&A professionals to being restructuring experts, because that is where quite a bit of action has been. And when we look at us as lawyers, we have seen how this entire spectrum has changed over the course of so many years. Let me come to 3 things which have changed in India. I think the first is the policy. 10 years ago, when the Insolvency and the Bankruptcy Code came out in India, the most important thing that happened was it was a sea change in the entire regulatory regime itself. It's not like India did not have an insolvency regime prior to that. It was just varied. It was just slightly all over the place. We moved on from that, and we look at what I call behavior. The reason I'm highlighting behavior is because I think that this specific legislation has actually led to a lot of change in the behavior of not just the borrowers, but also the creditors who actually avail financing, who actually provide the financing. Because as a jurisdiction, it was felt that India things are tough to enforce. Is security interest really meaningful? How long will it take in courts to actually get your money back? So when we look at creditor-led workouts, these were usually topics which used to play in the mind of any creditor when they were financing. But that has significantly changed, and we see a lot of discipline come in, especially in the borrowers. One unique thing that Indian insolvency law has is that if your account has been a non-performing asset under the prudential norms for a year, then you cannot bid back for your own asset. So there is a disqualification for the promoter to actually get back their own asset if they have been an NPA account under the Indian regulations. Now, this is very different from what we see in other jurisdictions, but this has seen, again, like I said, in addition to policy, the behavior change actually comes from here. So there is a inherent acknowledgement today that if I have borrowed, I need to pay back. And if I don't pay back, I may actually lose my enterprise in entirety from from a promoter's perspective. So we see that that has been a second significant change when it comes to India. The third and most important thing which ties into both of these is actually timelines. We look at any kind of creditor-led insolvency has an inherent conflict with the insolvency regime. And the reason I say that is, and I say that very consciously, when we look at any insolvency regime in any jurisdiction, the primary objective is resolution and not recovery. Whereas when creditors come into this regime, they are looking at recovery. Yes, resolution is in the larger interest, but at the end of the day, they have given the money and they want the money back. So when we look at a resolution framework, which needs to meet the objective of both the lender as well as the borrower, there is an inherent conflict. I think creditor-led workouts, which under the Indian regime is primarily outside of the formal insolvency process. At least today, yes, there has been a proposal to introduce the creditor-led framework. There is presently also something called pre-PAX, which is applicable to MSMEs. But keeping that aside, I think the key thing in India today is when we look at creditor-led workouts, we are primarily looking at two things outside of the formal insolvency process. One, we are looking at the RBI regime. RBI regime here is applicable only to which RBI is the Reserve Bank of India, which is the Indian banking regulator. They govern only banks and financial institutions in India. But Indian borrowers have a lot of money which comes from outside India, which is called cross-border financing or ECB financing. For them, the RBI regime is not applicable. So the only other alternative that exists is what both my colleagues touched upon earlier, both Veronica and Joe mentioned, are basically schemes or some sort of a formal framework which work under the, at least in the Indian context, it comes under the Indian Companies Act. Now, under the Indian Companies Act, it's actually quite interesting how schemes have evolved, because anybody can propose any class of stakeholder, whether it is a shareholder or it is a creditor. They can actually propose a scheme, and if it is having the approval of 3/4 of that class, and both by value and number who are present in voting, that scheme can actually go through. So creditor-led schemes of arrangement is provided for in the law, but it has never been used under the Companies Act. The reason for that is because, unlike other jurisdictions where there is a moratorium which comes in and there are some sort of borrower protections which exist, Indian schemes do not have that protection. So you're looking at two things then. You're looking at borrower cooperation at all points of time for a scheme to be effective. And you're looking at the borrower being in control. Also, one of the peculiar things, and this is coming more from the jurisprudence as to how schemes have evolved, is that you require this consent of majority by way of every class. So we have had situations where a particular class of lender, whether it is a foreign portfolio investor as a lender, or it's Indian bank as a lender, or it's an Indian non-banking financial institution as a lender. Each of them have claimed that they are a separate class. And for each class, you need to meet that majority test. So the majority test is not looked at under Indian law at just um, the borrower level, but it can actually be argued to be at each class of creditor level. That becomes a bit of a challenge because any creditor-led insolvency, I think, has some inherent risk. And to summarize, those two risks, at least in the Indian context, are dissenting creditors and crackdown. When it comes to dissenting creditors, these are creditors who may act as a holdout. Um, in a formal insolvency process, they may not necessarily have a complete say because majority can overrule decisions of the minority, and there is some protection being given even to dissenting financial creditors under the formal insolvency framework in India. But when it comes to anything which is informal or done outside of this process, there is a risk of these holdout lenders coming in, and they may actually hold the entire restructuring or a creditor-led restructuring, just at bay. And if, especially for borrowers who have a larger lending pool, it becomes a bit of a challenge to enforce it. The other principle which is linked to this is obviously cramp down and differential security interest. Now, interestingly, under Indian law, the entire jurisprudence around differential security interest held by creditors, I may have lent X amount, I may have been prudent enough to take 2x as collateral, but when it goes into insolvency, is only my debt value relevant, or is the fact that I was a prudent creditor earlier make any difference? Interestingly, this is a topic which is still pending decision by the Supreme Court. um, there are some principles coming out to say that when you are actually paying out such a creditor, and if such creditor has actually dissented to a resolution, you need to pay them out the value of their security. But this is not settled law, and that also gives some jitters to foreign lenders, to foreign portfolio investors when they look at India, because the first thing that they consider is it going to take time? And if I was prudent enough, am I going to be penalized, just because the regime does not necessarily support it today? When it comes to cross-border insolvency, interestingly, in India, there has been recognition. I mean, the most famous case that everybody talks about is the Jet Airways insolvency, which is the insolvency of one of the largest Indian airline companies, where there was a recognition given, though there is no formal adoption of the code, of the UNCITRAL code, or there is no formal cross-border insolvency which is formally recognized under the Indian insolvency procedure. What is relevant in the Indian context is that the courts on a case-to-case basis have been pragmatic. They have risen to the occasion and actually given credence to foreign creditors who are genuinely impacted by a particular decision, etc. So yeah, that's in a nutshell what India covers. And thank you again.
Thank you so much, Meena. With like Singapore, Hong Kong, and India, this is a very interesting segue right now to move to the EEA and the UK, predominantly because there are similarities close to the regimes that we have just spoken about, but actually that comparison is not very put forward in because of the nature of the localization of these regimes. So without any further from me, I want to now move to Norway and invite Stine Sniktendalen from Kvale to talk about the Norwegian regime and its uniqueness, but also, as you will find from her presentation, the similarities with the Indian landscape. Over to you, Stine.
There we are. Thank you, Ishana. You were given a lot of power here. You had the only power to unmute me. Okay, thank you for inviting me to this very competent panel from diverse jurisdictions. As Ishana said, I'm from a small country far, far north, Norway. You know it for northern lights, fjords, glaciers, midnight sun, and right now, no sun. So we have not adopted the model law. We are not part of the EU. We are EEA. We think we know best ourselves. We would like to do it our way. We tolerate our Nordic country friends, so we have a Nordic convention in place. But apart from that, we are a little bit the odd one out. As I'm going to talk about a little later, hopefully that will change in 2026, a little bit at least. So in Norway, we have only two sets of regulations on insolvency. We have insolvent liquidation or bankruptcy, which is very creditor-led, and we have reconstruction proceedings, a regulation that came in place in 2020, which is a very light version at the moment compared to what everyone has been speaking of today. But there's some legislative work underway. So starting with the insolvent liquidation in Norway, we are talking about creditor-led restructurings, and liquidation is obviously not a restructuring. However, it is sometimes applied as a restructuring tools and has been for many, many years because we have been lacking regulation on in-court restructurings. So because of that, we have had sort of pre-packed solutions without any pre-pack regulations applied in insolvent liquidation proceedings. And insolvent liquidation proceedings with bankruptcy in Norway is the debtor and the management and the board is stripped of all authorities, and there is appointed by the court an administrator who steps in and has all authority over the assets and rights of the debtor, together with one or a few creditor representatives. And what we do sometimes, and I myself is an administrator from time to time, is that we prepare the liquidation well with the buyer in place, ready to place a bid, who knows the business, and place a bid immediately after opening of liquidation proceedings. And through that, purchase the business as a going concern and takes over the assets and rights, but absolutely no liabilities, and can choose the number of employees they want to hire again, etc. So not a regulated process, but sometimes applied in Norway as a way of restructuring through liquidation. But then, as I said, in 2020, we got in-court reconstruction legislation as well. That was a little bit more modernized. It is very, very lightweight with a lot fewer tools and flexibility than most jurisdictions around us and our trade partners. But as what the practitioners have done is we've applied our creativity, and so we have been able to have quite a number of successful in-court restructurings through that regime. Nevertheless, as the sort of thin legislation also opens up for possibilities if you're a little bit creative, and we have been. So it's not that bad, but it needs modernization, which is on the way. So that's the debtor in possession scheme, the reconstruction. However, the creditors have some control as there is appointed an administrator by the court. And any major decision that debtor makes, like taking up new credit or selling large asset, needs to be approved by the administrator and a board of creditors. The administrator investigates the company and shall report to the creditors if there's any criminal offenses, clawback claims, etc. And when the proposal or the plan is sent out to the creditors, the administrator and the board of creditors are to tell the creditors if they recommend the creditors to accept the plan or not. So in all these aspects and a few more, the creditors have quite some saying into the process, and even though it is a debtor in process, the creditors may have a big influence. So what this current legislation has, they have very soft requirements for opening, just that the company will encounter financial difficulties in the foreseeable future, so easy to open. Automatic stay throughout the proceedings, no dividend requirements at all. So for instance, Norwegian Airlines had approved a dividend of 5% only payment to the creditors with 95% debt relief. The voting process and cram down regulation is in place, and the threshold is quite low. Only 50% yes votes in number or amount is sufficient to bind the remaining creditors to the plan. We also have a very light DIP financing arrangement, but it's insufficient as of now and hardly applied. But what the current legislation does not have is creditor classes and cross-class cram-down rules, obviously also. So it's the odd one out being we don't have any creditor classes. We only have priorities, you know, wages number 1, taxes number 2, the suppliers number 3. So we also don't have any pre-pack rules. We don't have any pre-insolvency proceeding rules. And prioritized claims, meaning wages and withholding taxes, are not included in the plan. They need to be paid in full. And any secured claim within the amount or the value of the security is also kept outside the plan and need to be paid or honored in full, which limits this process quite a lot compared to what you guys have all around the panel today. In practice, this has resulted in big Norwegians in court restructurings being carried out as they're done abroad, and then they are merely implemented through a reconstruction proceeding in Norway. So we have, for instance, Norwegian Air, a big passenger airline in Norway. They completed an Irish scheme of arrangement along with the Norwegian reconstructions. The administrator worked together, but the Irish scheme basically did all negotiations, and the plan was first accepted there, and when the creditors voted yes, they also signed the power of attorney to the Irish examiner to vote in their place in the Norwegian process, and the voting process in Norway took place immediately after the Irish process. The plan was identical, and the voting process in Norway was also successful. But in that way, the Norwegian Air reconstruction was successfully restructured both through an Irish scheme and a Norwegian reconstruction. We've done the same in Singapore. So I'm happy. I guess you're happy to hear that, Joe. Maybe you were involved even, I don't know. We had the company ProSafe, which did a Singaporean scheme of arrangement, which was successful, and then they implemented that scheme of arrangement in Norway through a Norwegian reconstruction as well. And you're nodding, so yeah, maybe you know it. And then, even though it's Sweden and Norway has quite similar regulation, not very similar anymore because Sweden has actually modernized there, as we are about to do. But the Scandinavian airlines that many of you might know, SAS, they did a US Chapter 11 not so long ago and implemented that in Sweden through a Swedish reconstruction. So that's the mechanism we've had so far and might continue with, because we get a much wider recognition internationally if we use schemes in the country that's more far-reaching and maybe where a lot of the vendors and contract parties are actually situated, which calls for cooperation between countries and our countries, so that's good. And now the Norwegian Justice Department is working on new legislation, and although we are not part of the EU, the government says that we don't have to implement any EU directive. They still said that, but let's make the rules consistent with the EU directive anyway. We don't have to, but we're going to try to do it anyway. The legislative work has been going on for a few years. by the Justice Department, and they have had a few meetings with the Norwegian Advisory Council of Bankruptcy to speak with the practitioners on how this will actually turn out in real life and not just on the paper with the legislation. And I've been a part of those meetings, and it's been a very exciting process. It's aimed at being enforced in July 2026, but the final proposal of the law is we're still waiting for that. So that's very exciting in Norway right now. What we will most likely get is creditor classes, cross-class cram down, secured creditors and owners will be included and made part of the plan, or at least it's possible to do that. And we will have a number of additional tools and regulation that is more in line with the EU directive and also with all you guys' regimes around the world, which are more and more, I think, seem to be more and more aligned for every year that goes, which is good to see for international trade. What we will most likely not get in Norway this round, there will be more rounds of legislation, but this round is that we cannot affect prioritized claims or employees at all. So if the problem is too many employees or too high wages obligations, it is not possible to do anything with that except for an insolvent liquidation. We will not get pre-pack rules, probably not pre-insolvency rules now. No scheme of arrangement kind of regimes right now. And no, the creditors will not be able to file or present their own proposal unless the debtor agrees, which is, then it's not much use. So we will have to wait for regulation on that. So I guess that was a brief summary of how the situation is in Norway right now.
You so much, Stine. I feel like I've given all of you a very hard task by asking you to summarize the landscape of your regimes. And I must say, as a teacher, you're all faring very well, 100 on 10 marks. Finally, we're at the UK, which is basically looked at as the master of restructurings as a concept. And I would now invite Charlotte Moller to wrap up and tell us why restructuring works in the UK and why the UK effectively led the way to make this happen.
Hello there. Sorry about the slight delay. So first of all, let me just say what a pleasure it is to join the panel today. And a special thanks to you, Ashana, for organising us all. So being the final presentation in a lineup of amazing speakers is always a bit intimidating. So I'm at least relieved to be representing the English team here. The system here has always been very adaptable, very pragmatic when it comes to restructurings. And even though we've got the infamous rule in Gibbs, which I know is not universally popular, although it's nice to have Veronica in Hong Kong on that side as well. The UK has at least been a leading light in the adoption of the various model laws on cross-border recognition of proceedings over time. So against this background, I think it's probably just worth noting that the English insolvency system has very much been founded on the idea that creditors' interests are paramount in any restructuring. And this is very much reflected in our administration and liquidation regimes, which I will touch on briefly. The more recent developments on the restructuring side here, where we've seen the sort of birth of our restructuring plan, which does have the kind of cross-class cram down, which is very hard to say, adopts a bit more of the debtor in possession approach, and certainly looks very heavily at both the EU directive on preventative restructuring of frameworks, but also across the Atlantic to Chapter 11 type concepts. So restructurings under English law can take a number of different forms, and there's a variety of tools that we use. Sort of stopping briefly at our Insolvency Act, which has what we would call the insolvency tools for a restructuring. The two most relevant for these purposes are probably the company voluntary arrangements, which broadly allow companies which have their COMI in the UK to restructure their unsecured debts. And that also includes a voting mechanism for creditors, for or against, but and leaves existing management in control, but with the actual arrangement itself having a supervisor who is an insolvency practitioner almost always. Secured creditors can't be bound by the CVA, however, unless they actually opt to be. And so you generally see it being used for situations such as retailers who actually want to restructure their lease portfolio. Then the second stop is administration, which it has the benefit of a moratorium that comes with it on proceedings. So you can't start proceedings against the company. Existing management exits stage left and the administrator steps in. And while in theory they're not meant to be terminal proceedings, they generally, well, and with an exception on restructuring plans perhaps as well, but they generally end up with a business and asset sale of the business. So you do get business continuity, but it's often through a pre-pack sale or through a sale of the business and assets a little bit later down the track, but with the administrator having managed the sales process as part of that. There's also a sort of myriad of special administration regimes in the UK, potentially a few too many now, and they are generally there to deal with companies which are in the regulated sector or have a particular purpose, so utility companies, for example. And in those, while it leans on the Insolvency Act legislation, creditors don't generally come first. So the focus there will be on clients, for example, in the financial services sector, or consumers if it's in the utility sector. So they're a little bit of an exception. The next piece of legislation, which is perhaps some sort of more interesting one for these purposes, actually comes out of our Companies Act. And that is where we started with the schemes of arrangement, which we're probably all very familiar with by this time. And Stina, if you ever want to come to the UK for a scheme of arrangement or a restructuring plan, we welcome everybody here as long as they have a sort of substantial connection, and we're really very flexible about what that connection can be. So it's certainly not COMI based only. So frankly, if you're finance documents have got an English law clause in them, you are very welcome here. And even if you've just swapped your finance contract to an English law, we'll still welcome you to the UK on that front. And essentially what the scheme of arrangement is it's another compromise with creditors that the existing management will put forward. And it's really just a court-supervised compromise with creditors with a voting mechanism. Now, the issue that we had with schemes of arrangement was that they did not have this cross-class cram down. And in a world where you have more holdout creditors, that was seen as very much limiting where you could get to with it. So you've divided your creditors into classes here. One of the classes votes against it. They've got, a 26% holding in that class, and you can't get your scheme of arrangement through. So with the COVID pandemic, we then saw the introduction of the restructuring plans. So they are 5 years old now, and still very much a maturing a product, I would say. Again, it's a compromise between the company and its creditors and its members. So you can also cram down the equity in restructuring plans. And in theory, it can be proposed both by management or by creditors or indeed by the members. But a bit like Veena was saying about the Indian model, in practice, it is extremely difficult to see how a creditor can realistically get a restructuring plan through without some cooperation from the debtor themselves. As for the schemes, those affected by the restructuring plan will be divided into classes for voting purposes. Those classes are based on people having substantially the same legal rights. And the threshold is slightly different to that, which is applicable for the schemes, because it's just a simple 75% in value. It can be, as I said, utilised by foreign companies, and we've seen that in a few cases. And actually, we've also seen it being used in parallel with schemes of arrangement. So, for example, for Hong Kong Airways and Sino Ocean, there was a restructuring plan in the UK, and then there was a parallel scheme of arrangement in Hong Kong. And the legislation provides for the court to have this discretion to cram down a dissenting class if certain conditions are met. And those conditions require that at least one class with an economic interest in the restructuring plan votes for it, and that there is and that the no worse off test is met. And that no worse off test focuses on the members of the dissenting classes not being worse off than they would be in what we term the relevant alternative. The legislation has been relatively light touch around how these principles should be applied. And there has been a lot of debate in recent case law about what the correct relevant alternative should be in these scenarios. Generally speaking, so far, it has either been liquidation or administration. So you're looking at what the returns to that particular class would be in those scenarios. But by its nature, it's always going to be a relatively hypothetical exercise. So plenty of room for argument. And I think what we have seen, perhaps unsurprisingly, given the power of the cross-class cram-down, is that we have quickly moved into a more contentious, far more litigious model with this, which has got a lot in common with what we've probably seen previously in the sort of Chapter 11 bankruptcy court room in the US. So it's sort of professionalized restructuring litigation, if you like, in the UK in a quite dramatic fashion. Important to note, the legislation doesn't introduce an absolute priority rule, so that gives us even more scope for flexibility on one hand, but also for argument about fairness. And there is a general discretion for the court as well to look at whether creditors overall are being treated fairly. There's been some attempt to sort of limit the parameters of the litigation. So we've got a new practice direction that has effectively come into force now, which is very much around how you do the case management for it, what level of negotiation needs to be done between creditors in advance, and how disclosure and the restructuring plan should be listed at court. The expert reports, which now are presented as part of a restructuring plan, now have to be done on a proper litigation basis, so with independent experts, which has necessarily added to the cost. So you really have ended up in a situation now where you will have a independent valuation, an independent expert on what the relevant alternative looks like, and very much more recently also a plan benefits report, which is really aimed at looking at what people are contributing to the success of the restructuring plan and whether they then get a fair result as a result of that contribution. And oh, the lights have come on back up in the room again, so I'm afraid I'm shining a bit brightly now. But there is still a lingering question around how you assess what is fair in terms of what people are contributing to the success of the restructuring plan and what they're getting out, and how you value that. So there's a lot of debate in the UK market as to whether we should be leaning into the sort of Dutch WOA model a bit more, of looking at what the post-restructuring enterprise value should be, or of a business is likely to be, or whether we look at things on the day of the restructuring itself. And there is a strong perception in the market that that restructuring plans have become riskier over the 5-year period because they now involve a lot more litigation. For those old enough to remember it, actually, I do feel a little bit like this might actually prove quite helpful in the long run. So we're sort of moving back to a stage where if you are going to present a restructuring plan, you almost have to have negotiated very hard with your creditors in advance, be able to show that you've had that negotiation, a bit like the London approach used to be. But now you've sort of added teeth to the situation, because if it proves that your creditors are being wholly unreasonable, you could then put it through a restructuring plan instead. And then just looking forward, we are hopeful that there might be a Supreme Court ruling around how out of the money creditors should be treated early in the new year, although the market rumour has that particular case has actually settled in the background. So unfortunately for the market, but probably good for the debtor, it appears that that may not get to the Supreme Court after all, because we would all, as practitioners, love to hear what the Supreme Court has to say on it, as it would provide a lot more certainty going forward for these types of plans. And then just touching briefly on recognition, I suppose it is worth saying that there has been a little local difficulty for restructuring plans with the district court in Frankfurt refusing to recognise a restructuring plan in Germany. Again, we are hopeful that that will actually be appealed, and then we'll see whether that is a kind of ongoing issue. The basis for the fact that the court refused to recognise it appeared to be on the fact that it didn't think there would be mutual recognition of a similar process in the UK. So my colleague Jens Rins has written quite an interesting article on our blog if anybody's interested in looking at that further. But that's clearly going to be an area to watch as well, because we are very keen to continue to export our excellent restructuring tools in the UK. Back to you, Ishana.
Thank you so much for that, Charlotte. Because I am the moderator and I have the privilege of asking the first question, I'm going to catch all of you off guard and ask the question about ask the question from the perspective of an unrepresented country here, which is the United States. Jared Elias, who's a professor of bankruptcy at Harvard Law, wrote on the expensiveness of the Chapter 11 process and the unsuitability of its enforcement and the value of the restructuring in itself, because of how expensive the restructuring under Chapter 11 is. And I just want to sort of take a beat and sort of deliberate on the fact that are restructurings actually cost efficient, and should they be pushed as they are? Because this paper, for anybody who wants to read it, also maps whether it is actually debtor friendly to do these restructurings based on the capitalization requirements of these restructurings. So a bit academic, perhaps throwing you off guard. If you think that this is something that just needs to be targeted from a large company perspective, and restructurings are customized to what they are, that's also fine. But I just wanted to do around the table while we wait for audience questions, if you had any thoughts on this. Sure, we could start with you, Charlotte.
Sorry, I couldn't unmute myself. I mean, that is definitely, the expense of a restructuring plan has definitely become a big issue in the UK. So they were set up originally with the view that they should be accessible by both small, sort of mid-market and large cap companies. Given the litigation that has gone with them at the moment, pre-packs are likely so pre-pack administrations are likely an easier option in the lower to mid-market, certainly if there's likely to be a challenge. I think once we get more stable case law on them, that might change. But at the moment, it's it's difficult to see how the mid-market isn't priced out from them.
I think in India it is slightly different, and the reason for that is that especially in large insolvency cases, invariably creditors have control now in the last 10-20 years over the cash flows of the borrower. So one of the things, and I'm not going into siphoning, I'm not going into routing of money by the borrower, etc. But if the creditors have access to cash, and if it is a genuine insolvency and the promoter is not a crook, and there is a cash mismatch sort of an issue, I do think it is actually a better solution. And the least expensive solution, in at least in the Indian framework.
Just adding my voice from Singapore. I do think the US probably stands alone in how expensive it is to restructure anything. Not just because of fees, advisor fees are huge, but also the extent of disclosure that's required in filing a Chapter 11, for example. That's I think way more than any of the other jurisdictions that I may be familiar with. And all of that goes towards like the cost that has to be borne by the debtor in the restructuring. In fact, I think the trend in Singapore is to the opposite. I'm more worried about a race to the bottom in terms of advisor fees and people just fighting to get instructions on the debtor side. So I don't think that problem is necessarily replicated, at least in Singapore, or perhaps the rest of the world. But I'm happy to hear from my colleagues on this.
Should I give a brief comment from Norway then? So since we don't really have a good tradition in the business market for restructuring, and is more like liquidation has been the only option for many, many years up until 2020, the companies file very late and have very little cash. So the processes need to be often, they don't have the money for expensive legal fees. So that reduces the cost in some cases, but it also pushes the companies to liquidation. When it comes to the new reconstruction rules, there is an advantage that the legislation is very simple and light and not complex at all. It's that it reduces the costs. And also in Norway, it's a civil law country, and the courts they are hardly evident in the cases. They open the cases and they close the cases. But in between, we rarely go to court in Norway. So the administrator drives the process, and any solutions with the creditors need to be negotiated. It's very, very, very rare, and not in every case, that we go to the court with an issue, which is completely different from your regimes and which is also cost reducing. So when it comes to costs, Norway is a good place to be. But then, of course, we need to go abroad sometimes, and that's a whole different matter.
A little bit from Hong Kong. I kind of echo what Joe says about the cost and all that. Agreed, but just want to share an experience is that sometimes we can also utilize the US regime. For example, I have a client, we're doing multi-jurisdiction restructuring, and then some part of them are in liquidation. We have absolutely no route to get any sort of disclosure from Hong Kong or Asia side of the world, because in Hong Kong we need separate application for disclosure, and often the court is a little bit more towards the bank. So unless the threshold to be satisfied is rather high. So we went through the US court under the Chapter 11, and through that we were actually able to obtain what we originally wanted to obtain through the Hong Kong procedures. So that's just a bit of sharing that I want to.
Thank you all for that off-the-cuff question, and the responses that we receive obviously are being mapped for a potential write-up or a newsletter. And I sometimes find it very interesting when you talk about the cost of bankruptcy or the cost of restructuring, and its utility has always been something that has been a question across the globe for a lot of academics. But what I want to sort of ask as perhaps the last question before I invite Aishna Kumar from iWork to talk to us a little bit about iWork India is the question of judicial cooperation and the use of international instruments when it comes to cross-border restructurings. Because from an India perspective, perhaps Bina is better placed to talk to us. Sorry, not the last question, because Jonathan also has a question. But I will let you have the floor then first, Jonathan, and then I will ask the controversial model law question at the end. Go ahead.
Sorry, it wasn't my intention to interrupt your question.
No,
Thank you very much.
You raised your hand later. I'm being a good moderator.
Okay, thank you very much, Ishana. So first and foremost, thank you very much to all the panelists. I learned a lot. I have a question on the success rate of your respective frameworks, because I mean in Sweden we implemented the EU directive, I think it was a bit over 3 years ago. And I did a research project and we tracked every case for the first 2 years. That's like 360 cases or something like that. And we saw that somewhere around 40% managed to put a plan forward and get it confirmed by the court. So 60% did not even manage to put a plan forward and get it confirmed. They failed, they went bankrupt before even getting to that stage in the process. And even further cases, even further companies are going into bankruptcy after exiting the proceedings. So I don't think the directive and this new framework in Sweden has been a success story. Lots and lots of failing cases. Would you say that 40% success rate is okay? Is it better in your jurisdictions?
I can go first since I'm your neighbor there. We have more than 50% success rate from the legislation from 2020. I think a lot of the companies that fail, they use the regime the wrong way. They use it as a defense rather than an offense to stop any petition for bankruptcy or stuff like that without a lawyer, maybe even representing them, and perhaps without the money to actually pay for the proceedings. So I think a part of the reason why this fail is that they don't apply it the right way, and it's the lack of knowledge actually of what it is. Some others that fail, I think, might get a softer landing if they start with a reconstruction, even though they fail. Because if you go directly into a Swedish or Norwegian liquidation, you go heavily you're smashing into a wall, basically. Even more in Norway than in Sweden, I know. And in Norway, the business has to be solved within maybe a few days, maximum 1 or 2 weeks. In Sweden, you have a little more time, but you don't have a lot of time. And if you start with a reconstruction, even though it fails, it might not be a failure as such, the combined process, because you might get a little bit softer fall into the liquidation.
From the UK perspective, I mean, I don't have the statistics for how many of the plans have not been sanctioned, but I think it might also not tell the full story, even if you did, because certainly the fact that there now is a restructuring plan option there I think has focused a lot of people's minds when it comes to negotiations, and perhaps made some of those negotiations outside of the regime a little bit more reasonable. So anecdotally, there are quite a lot of examples where you've gone to the table with something and said, well, we would like to do this out of court because that would be a lot cheaper for everybody and a lot more certain and put less strain on the company, on the debtor. But if we can't get this through as a negotiated compromise, a debt for equity swap or whatever it's going to be, then we will push it through a restructuring plan. So some of the success of the legislation is perhaps just the fact that the legislation is there in the first place. Now, there have been a few sort of high-profile cases where the restructuring plans haven't been sanctioned. So I suppose Petrofac is the kind of obvious one at the moment. But even there, the fact that what has then ultimately happened is that the company's gone into administration may actually provide a little bit of a lesson as well in terms of what the consequences of not coming to a reasonable position for all parties, debtor as well as creditors, may end up being, because I very much doubt that they will get the same returns as they would have got under the restructuring plan.
I think India, it's a little difficult how you, how you can actually compare this number. If you look at the formal insolvency process, certainly a huge success in terms of having a resolution. Whether that's a meaningful resolution, if you look at the newspapers in India, you will, especially in the last 6 odd months, you will feel no, it is not really very meaningful. But if you look at the 18-month period before that, it has been fairly successful. But if you look at outside the formal process, how successful it has been for larger accounts, very limited. And the main reason for that is your holdout or dissenting creditors, and you cannot really have a meaningful plan outside the formal process without binding everyone, or at least everybody agreeing to have such sort of a plan. So that's always been a challenge in India.
Yeah.
Well, this from a Singapore angle, judicial management is notoriously known for being unsuccessful in the sense of, well, recently there was a committee report that looked at judicial management's success rate from 2017 to 2021. And then, of course, we have statistics from before that, but of the 99 cases reviewed, slightly less than half were treated as successful. So we're up there with the statistics in Norway, for a fact. But I think my personal view is this, right? These are just structures. These are just tools, right? And you can tweak them to give creditors more power, to give debtors more power or more say. But if there's no new money in the system or market conditions aren't changing, your restructuring, there is a high chance that your restructuring is going to be unsuccessful or it's not going to move. So really there's a confluence of many, many factors. And it's very hard to say that this tool wasn't good enough because 50% of the cases during this period failed. It might just have been a period where everything in the economy was really stagnant and nobody had a solution. I suspect this is very much the case in China. I know that Veronica will probably have something to say about the Chinese landscape, but that really is my hypothesis. You can talk about the tools, you can try and refine it, but there are many, many extra factors that we have to think about.
So to carry on from a PRC Hong Kong perspective, it's hard to say because we don't have a lot, but I'm sure all of you are aware that recently there are a lot of the Chinese estate-related schemes or insolvency. So amongst all these, we say it's still a good prospect. We have above 70% success rate. But then it's often due to the different class of creditors that you need to cater, and often because of the jurisdiction. When some of them are in Hong Kong or some of them in the PRC, there's always that difficulty of the flow of cash. Because if you want cash to come in from China, you need additional applications or sanctions from the PRC government, which is always difficult. So you have to split the classes very carefully, and that will be one of the challenges. And also because of the cooperation mechanism we have implemented, which provides an easier way for insolvency practitioners to go around difficulties. Therefore, schemes are actually not as popular as insolvency proceedings, like other insolvency proceedings. That said, I think the court in both PRC and in Hong Kong are a little bit more willing, to grant the scheme. However, we have seen cases also related to property developers. They've granted the scheme, but 3-4 years later, we still have to go down to the liquidation route. And probably that is also why put the insolvency practitioners on hold as to whether to choose to go for a scheme or rather go for liquidation. Because with property developers, not a lot of them actually have assets around to be restructured in the first place. So, so there are a lot of the other difficulties which limit the number of schemes. But I do believe that the development of the law we have in both Hong Kong and PRC do allow the insolvency practitioners to have a fair choice between a scheme or liquidation. And I do think it will be more developed in the coming years. So I think we'll just have to wait and see. And as Joe said, it's also a global economic problem. So I don't have an answer to that, but this is just like the trend of where we're at and what I foresee will be going on.
Thank you so much, Veronica. Some positivity out of the outlook from different jurisdictions is a best way to sort of wrap up. With that, I want to invite Aishna, who is representing the partner for this program, which is iWork and the India chapter, and talk to us a little bit about what iWork India does. And then I'm going to say thanks and leave a cliffhanger for the question that I could not ask. Over to you, Aishna.
Right. Thank you so much, Ishana, for that. And thank you so much for this brilliant panel, giving us so many different perspectives on a very common regime that we look at almost every day of our life. And it's actually been one of the most, enriching discussions that I have come across. And thank you so much, Ishana, for collaborating with us from ILA, because to bring this panel together with so many speakers, with so many perspectives, and still have a common ground of talking about schemes makes us feel much closer in terms of the world affairs. I, on behalf of iWork India, would like to say that we are an organization in terms of a think tank, and we try and carry out various webinars and conferences annually as well as biannually in order to bring the insolvency sector in India, and also to create awareness amongst the insolvency practitioners, not only lawyers, but as well as academicians, in order to understand what are the issues that are being faced by India internationally. And we also have a newsletter that we issue every month for the purpose of covering those issues. We look forward to such collaborations, and I thank everybody on the panel and ILA for this collaboration on behalf of iWork India. Thank you.
Thank you.
Thank you so much, Ishna. We're bang on time to wrap, so that's fantastic. I want to thank Veronica, Joe, Charlotte, Stine, Veena. Thank you very much. I'm extremely grateful that you banded together for this. I apologize to have chased you the way that I did, but you're friends of mine and you forgive me. So thank you. Jonathan, Ishna, this would have not been possible without the two of you ganging up and supporting me. So thank you, iWork. You've been brilliant. And thank you, Insolvency Law Academy, for being the platform that makes these things possible. I want to do a shout out to Vaidehi Gulati, who manages, chairs, makes all of this happen from ILA. So thank you very much. We are an early scholars group. This is one of the first initiative partnerships that we've done at a global stage with iWork, and we hope to do this on an annual basis. We may repeat speakers, we may not repeat speakers, but that's something for you to find out. So register next year as well. As a cliffhanger, I want to leave the question that I was about to raise as the hot topic question, which is, how important is judicial cooperation for cross-border restructurings, and how effective are cross-border restructuring plans in general, which is the topic of our next session. We will, of course, have UK lead the way again on this. So stay tuned, follow us, subscribe to iWork and ILA, and we hope to see you next year. Thank you all. Thank you very much for taking the time to be here, and hope you have a good rest of the day, evening, night. Thank you.
Thank you.
Thank you.
Thank you.